Hello, thank you for joining us for our CARE community briefing on immigrant rights resources. My name is Kat New, and I serve as the Director for the Office of Community Awareness, Response, and Engagement, known as CARE, at the California Department of Justice. Before I begin, please note that closed captioning is available by selecting the More tab in the menu bar on your screen. Spanish and American Sign Language interpretation is available by selecting the world icon. We know that many people in California and across the country are feeling anxious, scared, sad, and uncertain about the incoming federal administration. Regardless of who is in the White House or Congress, Attorney General Bonta, California DOJ, CARE, my colleagues, and myself are all here for you. As Attorney General Bonta says, in California, progress will prevail. We faced a Trump presidency before, so we have an idea of what to expect. We're anticipating an early influx of executive orders and rulemaking and interpretations of statutes that we don't agree with. During the last Trump administration, California DOJ filed more than 120 lawsuits and won the vast majority. We successfully fought Trump's border wall and preserved DACA. We have to see what challenges come and how we'll need to respond within the bounds of the law and authority of the office, but you can be sure we'll be ready. We also want you to be ready. This community briefing focuses on three resources issued by the California Department of Justice over the last several weeks. One is focused more broadly on immigrant rights and protections under the law. The second is on spotting and avoiding immigration-related scams. And the third is for public institutions like libraries, courthouses, and public health facilities on best practices in avoiding the use of state and local resources to support civil immigration enforcement. We will also share two resources we issued just this week to help ensure the educational rights of immigrant students and their families. We are honored to have a representative from our Civil Rights Enforcement Section, Joel Marrero, Supervising Deputy Attorney General, joining us today to walk through these resources for us. Afterward, he will respond to some of the questions that you have submitted. Joel, thank you for your work on developing these materials and sharing more about them today. I'll hand it over to you.
Thank you, Kat. Good morning, everyone. Thank you for joining us today. I will provide an overview of the California Values Act, also known as Senate Bill 54. And within Senate Bill 54, specifically the provisions that pertain to our office's mandate to develop guidances and model policies with respect to shelters, libraries, healthcare facilities, labor agencies, courthouses, colleges, and K-12, which also, to mention here, Assembly Bill 699 also directs our office to develop model policies with respect to public schools K through 12. So both SB 54 and AB 699 require the same for schools K to 12. An overview of the California Values Act. In 2018, California enacted the California Values Act to provide direction to law enforcement and other public agencies on when and how they can interact with federal immigration enforcement. In the California Values Act, the legislature found that immigrants are valuable and essential members of the California community, that a relationship of trust between California's immigrant community and state and local agencies is central to the public safety of the people of California, and that trust is threatened when state and local agencies are entangled with federal immigration enforcement. To preserve the trust that immigrant communities instill in our law enforcement and public agencies. Among other things, the California Values Act directs the Department of Justice to promulgate model policies and guidances that limit assistance with immigration enforcement to the fullest extent possible for the following public institutions. I mentioned those earlier: shelters, libraries, health facilities, labor agencies, courthouses, colleges, and schools K-12. One thing to note here is that all public schools, health facilities, and courthouses are required to implement the model policies or their substantial equivalent. A few things to also note. The public schools, healthcare facilities, and courthouses I mentioned are required to adopt these policies. California Assembly Bill 699, which I mentioned earlier, is also that the model policies regarding K-12 are based on the mandates found under Assembly Bill 699. You will also notice that SB 54 speaks only to some public agencies, again, schools, courthouses, public shelters, but does not speak to other public actors like City Hall staff. SB 54 gives local jurisdictions the ability to enact their own sanctuary protections as long as those protections don't conflict with SB 54. Here's an overview of the legal principles upon which the model guidances and model policies and guidances are predicated. SB 54 directs the office to develop policies regarding these public institutions, and that the policies are based on this principle that federal immigration enforcement should be limited to the fullest extent possible. This means that the guidances are based on the law at the time in which the guidances were issued. The model policies and guidances were initially developed in October 2018 after office convened groups of stakeholders tasked with shaping the model policies and guidances in accordance with the law and best practices. In December 2024, our office updated the guidances to ensure they were current with the law. It is important to keep in mind that the guidance's development and subsequent update were based on federal and state laws, regulations, and policies current as of the date of publication. Given this, we caution you to use the guidances as tools for understanding the law, and if the need ever arises, to consult with an attorney to determine if the law or policy upon which the guidances are based change at any moment. The guidances also account for a really important federal law, 8 U.S.C. 1373. That law states a federal, state, or local government entity or official may not prohibit or in any way restrict any government entity or official from sending or receiving from the Immigration and Naturalization Service information regarding the citizenship or immigration status, law or unlawful of any individual. The Ninth Circuit has narrowly construed Section 1373 to only pertain to information about citizenship or immigration status. What does this mean? It means that if ICE were to request from any of the public agencies that are subject to these guidances information about a particular person's immigration status, under Section 1373, the state and the agency head cannot limit the employee's ability to answer questions from ICE about a particular person's immigration status. However, Section 1373 does not mandate the collection of immigration status information, does not mandate the retention of immigration status information, does not pertain to groups of people because it only speaks about individuals, and does not, on its face, limit the individual government employee or individual who receives this request from ICE from refusing to comply. Lastly, as I mentioned, the guidances are based on policies current as of the time in which the guidances were issued. This includes the ICE policies on protected areas. Policies are much easier to change than laws. If the Trump administration revokes the ICE policy on protected areas, the guidance's reliance on that particular policy should be considered outdated. I know we only have a few minutes, so I'll try to go over this as quick as possible to allow time for some questions and answers that we received in advance of today's presentation. So the shelter's model policies and guidance. The guidance provides an overview of legal protections that apply to shelter clients. These include protections against discrimination and protections found under privacy laws. The guidances also provide an overview of policies and guidance regarding the collection, retention, and sharing of sensitive client information. The guidance makes clear that shelters generally have no affirmative obligation to inquire into a person's immigration status, nor an obligation to retain information about a person's immigration status. If shelter staff were to receive an inquiry from ICE about any person's immigration status, if that shelter staff has no information about a person's immigration status, I don't know would be a reasonable and honest answer to ICE. The guidances also provide an overview of legal protections to shelter clients who have been victims of crimes. These include protections found under the Violence Against Women Act, or VAWA. The guidances also provide information to shelter staff about policies and practices for responding to ICE officers engaged in immigration enforcement. Shelter staff are encouraged to develop policies for collecting and receiving and processing client information. And they're also encouraged, again, to immediately contact their attorney if ICE were to ever make a request to enter a shelter or to request information about a shelter client. The guidances also provide recommendations to shelter staff regarding limiting ICE access to shelter facilities or clients. So if ICE, for instance, were to appear at a shelter, the guidances provide an overview of what shelter staff should and shouldn't do. Some of this, I should say, a lot of this is really based on Assembly Bill 450, which prohibits public employers from providing voluntary consent to ICE to enter non-public areas of a public facility. This includes areas of a shelter that are not open to the public. So if ICE were to appear at a shelter and they were to have, let's just say, an ICE warrant, shelter staff, and I'll provide an overview of the distinctions between ICE warrant and judicial warrant, but shelter staff are not required to comply with that ICE warrant. Shelter staff and all employees who operate at all these facilities subject to these policies are always encouraged to immediately contact their attorney if they were to get any type of request from ICE. The guidances provide an overview, as I mentioned, of ICE warrants and judicial warrants. So I'll briefly describe what those are. An ICE warrant does not grant an immigration enforcement officer any special power to compel staff to cooperate with his or her request. Again, staff are encouraged to immediately contact their attorney if they were to get an ICE warrant, or if an agent were to appear with an ICE warrant. A notice to appear notifies an individual that he or she is expected to appear before an immigration judge on a certain date. And notice to appear does not authorize an individual's arrest by ICE, by immigration enforcement authorities or local law enforcement authorities. If an ICE agent appears at a particular facility with a notice to appear, staff are not required to comply with a notice to appear. A federal court warrant is issued by a district judge or a magistrate judge of a U.S. district court based on finding of probable cause. Unlike an ICE administrative warrant, a judicial warrant, a staff that receives a judicial warrant or an ICE agent that has a judicially issued warrant, compliance is required under these circumstances. An administrative subpoena is a document that requests production of documents or other evidence. and is issued by an immigration enforcement officer, immediate compliance is not required. Lastly, a federal judicial subpoena is a document that asks for documents or other evidence. An administrative subpoena, I should say, like an administrative subpoena, a shelter staff need not immediately comply with a judicial warrant. As a judicial, I should say judicial subpoena, as a judicial subpoena can be challenged in before a federal judge in a U.S. District Court. I know we only have a few minutes left, so I will try to go over this as quickly as possible. The model policies also, as I mentioned, speak to libraries, and they provide an overview of patron information not subject to release by California libraries. This includes an overview of privacy laws. The guidances also provide information to library personnel regarding requests for physical access to libraries from immigration enforcement officers. This, again, is predicated on Assembly Bill 450, which prohibits public employees from allowing ICE officers, providing access to ICE officers to non-public areas. This includes non-public areas of a library, of a public library. The guidance also provides an overview of the types of administrative and judicial warrants, subpoenas, and other documents that seek access to places, individuals, or things, such as the ones that I just went over a minute ago. And they also provide policy recommendations regarding access to places within library or patron information that libraries may possess. The healthcare guidance and model policies, they provide a high-level summary of state and federal laws that govern privacy and patient information, including the effect of receipt of health benefits on migration status. They also provide an overview of federal privacy laws, such as HIPAA, and state privacy laws. The model policies also provide an overview of protections against that relate to the release of patient or family information to the extent permitted by law. And they also provide an overview of laws and model policies regarding immigration enforcement official requests for physical access to a healthcare facility. Again, these protections are based on those found under Assembly Bill 450. The policies pertain to courthouses, provide an overview of laws governing immigration enforcement actions, such as arrests, interviews, searches, and surveillance of courthouses. They provide recommendations to courthouse staff regarding immigration enforcement activities at or near courthouses. They provide an overview of immigration policies regarding victims and crime victims and children. So an overview of laws and policies that pertain to victims of crimes and children. They also provide an overview of policies limiting access to restricted areas within state court facilities. This includes, again, those limitations found under Assembly Bill 450. And finally, they provide an overview of model policies regarding the collection, storage, and release of information. One thing to note about the courthouse policies is that they're partly based on current ICE policy. Some of these policies are likely to change with the new administration. With respect to the model policies and guidance on colleges, this document provides an overview of laws and policies regarding the collection and retaining of student immigration status and other sensitive information. This includes guidance and an overview of laws pertaining to information found in or retained by admissions records, financial aid, campus housing, campus police, student disciplinary records, campus healthcare facilities. They also provide an overview of laws and policies regarding immigration enforcement requests to access campus facilities and residential units. Again, predicated under AB 450. So if ICE were to enter a public college or university and request physical access to a particular area, college staff are not required to provide ICE access to non-public areas, say for instance, college dorms, unless of course that ICE agent were to have a judicial warrant with them. The model policies on K-12 provide a summary of laws that govern the collection and protection of student information, including immigration status information, social security number, enrollment, and enrollment information. They include model policies regarding the collection and retention of student information, as well as a summary of laws and model policies instructing school districts on ways to protect against the release of student information. This includes information about a student's immigration status or their family or the status of a family member. And they also provide information to school administrators on policies and practices for responding to immigration requests for access to school facilities, student information, or contact with a student. One thing to note about the K-12 model policies is that they also provide guidance to school officials about what to do when a child or a student is separated from their parents because of an immigration enforcement action, because they're in removal proceedings or they've been arrested. Our office also recently issued an update to the Know Your Rights information or materials. Those are found on our website. This includes the right to an overview of rights to free public education, information required for school enrollment, confidentiality of personal information. You also have the right to apply for and secure housing without sharing your immigration status. You have the right to access emergency medical care. You have the right to an attorney. You have the Know Your Rights also provide an overview of state and local law enforcement obligations, particularly limitations against inquiries into a person's immigration status. They also provide an overview of state and local law enforcement limitations against the types of information that they can share, including personal information. And they also provide that state and local law enforcement cannot assist ICE with immigration enforcement with very limited exceptions. So as I mentioned earlier, we received a number of questions in advance of today's presentation, and I will answer a few of those. One question, and I believe this was answered by one of the prior slides, are emergency and urgent care services available to undocumented people? The short of it is yes. Do the model policies on schools apply to adult schools? Generally, yes, and that's because adult schools are part of school districts, and school districts are subject to Assembly Bill 699, which mandates the development of these model policies and mandates that school districts adopt the model policies issued by our office. Another question, do we have any concerns about federally qualified health centers? We have no specific concerns about these centers, but we just want to remind you that only publicly operated health facilities are required to adopt the model policies and guidance. Privately run, federally qualified health centers have the discretion to adopt these policies. Do the model policies apply to behavioral health facilities? Yes. The model policies do not distinguish between different types of licensed facilities. SB 54 defines health facility broadly to include many different types of health facilities. However, again, only publicly operated behavioral health facilities are required to adopt the model policies. We received a number of questions about hate crimes, and this is something that our office is particularly concerned about always, regardless of who's in office, but we are acutely aware that immigrant communities are likely to be subject to hate crimes and other forms of harassment by private individuals. We want to encourage anyone who is a victim of a hate crime or who witnesses a hate crime against any person to immediately contact law enforcement, as they are the first line of defense against hate crimes. If you are a victim of a hate crime or witness a hate crime, you can also file a complaint with the California Civil Rights Department. They will investigate the complaint from a civil standpoint. And if you have a complaint against a local agency, say a local law enforcement agency, because you believe that they have not fairly or appropriately or adequately responded to or investigated a hate crimes complaint, you can file a complaint with our office. You can also file a complaint with the California Civil Rights Department. Any information to students concerned about information sharing when registering for aid or financial aid or other resources? This is a really complicated and important question. But what we will say currently is that student or that family should work with their financial aid officer to explore all options that may be available to that student, and to work with the university to ensure that the student's information is protected to the fullest extent possible. I know we have a minute left, Kat, but I know that we got a number of questions about what can folks do for families? What can we do for each other? A lot of people right now are in fear of what's to come. And, I think one thing I will say, before I came to the DOJ, I worked at another state attorney general's office. I practiced many years as a legal aid attorney, so I understand firsthand the need that communities have for legal resources and assistance. I will, the one piece of information that I will leave with folks is to do your best to understand what types of legal resources exist within your community. There are a number of organizations out there that do amazing work, but not all of them are there to provide the type of assistance that you may need. So it's important to develop a Rolodex, really map out who's who in your community, who provides assistance on housing and education, which organization may be able to help in the event should you or a family member end up in removal proceedings or engage with a local law enforcement agent in a way that may be harmful to you or that family member. You can find that information on our website. Kat, do you want to provide folks a sort of an overview of where particularly that information can be particularly found?
Yes, thank you. So you can find that sorry, can you go to the previous slide? Yes. So the resources are on both of these web pages. So where you may have RSVP'd for this webinar on the community briefings page, oag.ca.gov/care/community-briefings, or directly accessed at oag.ca.gov/immigrant/resources. So you'll be able to get those model policies along with today's PowerPoint as well.
Thank you, Kat. I just want to make a quick plug for Immigration Law Help. There's a hyperlink on our immigrant resources webpage. There are a number of resources there. You will, this is time consuming. You will have to do your homework and really peruse that webpage to see what resources are available in your community. But we really encourage you to do what you can to inform yourself about the types of resources that are out there that could be helpful at any given moment.
Thank you so much, Joelle, for the very informative presentation and for walking through the different publications with us today, and also for answering the questions that came in through the registration form. So to share with all of you, you will be able to access today's presentation shortly after the conclusion. The PowerPoint presentations are on our website now, oag.ca care/community-briefings, along with the legal resources that Joelle mentioned. To conclude, I wanted to share that Attorney General Bonta and our team at the Department of Justice are preparing to protect and defend your rights, including reproductive rights, immigrant rights, housing justice, environmental justice, racial justice, and economic justice, be it through legislation, through litigation in court, or through responses to executive orders and dangerous regulations. California DOJ will continue to protect, defend, and serve every single Californian. We invite you to stay connected with us at care@doj.ca.gov. Our next CARE community briefing will be on January 21st, where we'll take a deeper dive into the recently released Racial and Identity Profiling Act annual report. Register at oag.ca.gov/care/community briefings. Thank you for joining us today. Stay safe.